Okay, hi everyone, and welcome to our first session, or non-keynote session, about third-party status. It's a very interesting and practically important subject. And we have two fantastic speakers today, Dr. Alexander Venker and Professor Yael Runen, and I will introduce each one of them before they speak. I will follow, I think, the highest of precedents by being brutal, as Professor Kretzmer was, in terms of time, because we are running late as it is. Our first speaker would be Dr. Alexander Venker. He's currently a senior research fellow at the Max Planck Institute for Comparative Public Law and International Law in Heidelberg, and a legal trainee at the Higher Regional Court of Berlin. He teaches international dispute settlement at the Free University of Berlin and has clerked at the Supreme Court of Namibia. He has completed his doctoral research recently, so congrats, Alexander, under the supervision of Dapo Akande and Miles Jackson, precisely on this issue. So, Alexander, without further ado, third-party status in the conflict of Ukraine. So, if you want to...
Yeah, I can come over. Thank you, Elia, for the very kind introduction. It's a pleasure to be here. Well, since the early days of Russia's invasion of Ukraine, as all of you are aware, many states have provided military assistance to Ukraine. That support includes all sorts of weapons and training on those weapons. Crucially then, a number of states also provide battlefield intelligence, and reportedly, some states have also assisted Ukraine by cyber means to disrupt Russian cyber operations and communication channels. Now, this support has been accompanied by an intensive public debate about whether and at what point this support could make Western states parties to the war. In my own country, Germany, there seems to have been perhaps a particular obsession with that notion of becoming a party, to the point that this question has featured prominently not only in debates in the German Bundestag, but even in talk shows and in open letters that were being written to the government by more or less well-known public figures. Now, to my mind, and I think that in other states too, including perhaps in the US to an extent at least, there has also been quite some debate on when support would make one a party alongside Ukraine, so what would traditionally have been called a co-belligerent, and what we might, in more modern terminology, also refer to as a co-party. Now, to my mind, these debates have revealed that the concept of party status is still insufficiently understood. I think there is uncertainty as to what it would mean to be a party to an international armed conflict and as to when that line is crossed. And I believe that this question is actually relevant beyond the war in Ukraine. States have always relied on the support of others to wage wars. And as military technology advances, we're seeing increasingly complex forms of cooperation that crucially shape today's wars, as I think they'll shape tomorrow's. And with my paper, I try to make a first step towards addressing that need for reflection on party status. And to introduce it to my paper, I'll structure the remainder of my presentation as follows. So first, I will briefly clarify why it matters under international law who is a party to an international armed conflict. Once that is settled, I will then attempt to sketch out in rough terms the legal criteria for identifying who is a party to an international armed conflict. And this will include some thoughts on the temporal scope of party status. So when does it begin, when does it end? And finally, I'll then tentatively try to apply that legal framework to the different forms of military assistance that we're seeing in Ukraine, just to illustrate a bit how the framework might play out in practical conflict settings. So on the first point, what does it mean in legal terms to be a party to an IAC? Well, if we look at the political debates in Western states, I think that party status has featured so prominently, partly because of the enormous political implications that it would have for Western states to be at war with Russia. At the same time, though, there seems to have been an underlying assumption, at least in some states, that being a party alongside Ukraine would somehow entitle Russia to use force against Western states. Now, that legal connotation, to some extent, is reminiscent of the traditional meaning of being in a state of war, right? This idea that war and peace are separate legal spheres, and in the sphere of war, the contestants may bring each other down by force. Now, that is difficult to square with how international law today regulates war, because as Professor Sassoli so rightly recalled this morning, chiefly the prohibition of the use of force also applies as between parties to an international armed conflict. So from that perspective, being a party does not anymore put the belligerent states in an entirely separate sphere of war, as it were. And this means that Russia would commit further violations of the jus ad bellum if it were to attack Western states, even if these were to be considered parties to the conflict. Now, this may seem to be an obvious point to make to such an expert audience, but I think it's worth making this point clear because there has been quite some confusion on this point in public debates in recent months. Now, of course, under the jus in bello, being a party means that members of that state's armed forces would be combatant, and as such, they'd be lawful targets for the adverse party. And more widely, party status does have a wide range of significant legal implications. In general terms, I think it's fair to say that the regulation of armed conflict today is still, in a great many ways, organized around the concept of party status. Parties bear central obligations under IHL. Parties were traditionally at least also thought to have certain belligerent rights, such as establishing blockades and seizing contraband and so forth, though one should say that these rights are increasingly called into question, and their exercise, to my mind at least, is also curtailed by the jus ad bellum. And parties are not only addressees of IHL, party status is also relevant to determine which rules apply to individuals in armed conflict, not only as regards combatants, but also because categories of protected persons are generally defined through a certain connection to the parties or a party. And the connection to the party also matters for establishing international criminal responsibility for war crimes, even if more subtly, for example, as part of the indicators that are used for assessing the nexus requirements, which all, to some extent, rely on a connection to the parties. And then party status is relevant for the geographical scope of application of IHL, and identifying who's a party matters for the legal relationship between parties and third states, so particularly under the traditional law of neutrality. And finally, party status may even have implications beyond IHL. Notably, it may modify how certain human rights obligations apply. So in sum, who is a party matters in a number of ways. So how then can we tell? And this brings me to the next part of the paper. Now, sadly, international law has no rules that were specifically designed to identify who is a party to an international armed conflict. In particular, and this is something that I would like to clarify up front, the law of neutrality, to my mind, does not contain these rules. Neutrality law requires states, amongst other things, not to assist the belligerents. And now some have argued that significant violations of neutrality duties would make third states parties. Now, we'll leave aside here all the debates on whether neutrality law is still meaningful at all today and how, if it is, it could be applied to the war in Ukraine. In any event, I think that we should keep the question of whether neutrality law is violated strictly separate from whether that status is terminated. And I explain this in some more detail in the paper. So instead of relying on the law of neutrality, I argue in the paper that the structure of the law of armed conflict, if we read it in light of past practice, suggests two criteria plus one specification. So to become a party to an international armed conflict, a state must first make a contribution to the conflict that has a direct operational connection to harm caused to the adversary. Secondly, that contribution must be so closely coordinated with the other party or parties on the same side of the conflict that the state can be said to be involved in the decision-making processes on the coordinated military operations. And the specification is that these two criteria must be fulfilled while the state acts knowingly. So let me briefly walk you through these elements one by one. First, regarding the operational character of a state's contribution. Now here, I don't think a state needs to perform acts that would suffice in and of itself to create an international armed conflict in the first place. That may not be a very high bar in practice in any event, but I think that conceptually it's worth stressing that there is no need to require this creation of a new IAC when such a conflict already exists. Still, armed conflicts, whether international or non-international, consist of hostilities or military operations at their core. So structurally, therefore, I think that the acts of the state must form part of these hostilities for it to become a party. Hostilities or military operations, which I use synonymously here, are the essence of the conflict relationship between the parties and can be defined broadly as acts which cause harm to the adverse armed forces. So I think it makes sense to require that the acts of a state have a direct connection with harm to the adversary. And as I illustrate in the paper, I think this also resonates with how states have understood the contours of party status in past international armed conflicts, although of course these understandings in practice have remained murky often. Now, what exactly a direct connection means is not entirely settled. To my mind, one practical way forward, though certainly not the only conceivable one, is to rely on how the ICRC has understood the element of direct causation of harm in the context of civilian direct participation in hostilities. This would mean that the acts of the state must cause harm to the adversary in one causal step or form part, an integral part of coordinated military operations that do so. So the second criterion then, and this concerns the character of the relationship between parties on the same side or co-parties. It's not enough, to my mind, for multiple states to simply fight a common adversary simultaneously, because after all, one state can be involved in multiple separate armed conflicts at the same time. So what ties the acts of multiple states together so that they become co-parties is the fact that they coordinate their military operations in a way that they build on one another as contributions to one armed conflict. The exact degree of coordination that's required is hard to pin down, and I think it's helpful to keep in mind that IHL envisions the parties as central players in an armed conflict, and as such they have the primary responsibility to ensure that the conflict is conducted in accordance with IHL. Now that assumes that parties decide how the conflict is conducted, so perhaps the actual operational decision-making must be key to party status. And if that's true, then the coordination between multiple parties on the same side must be such that each of them has a role in the decision-making processes on the coordinated military operations. Now, if we have a sufficiently coordinated operational contribution by a state, then the party status of that state does not depend on whether the state wants to be a party or not, obviously. We leave aside here that, of course, theoretically there could still be a declaration of war, but usually there isn't. And states don't need to intend or know the legal consequences of their acts with respect to party status. But I do think that they need to be aware of the relevant facts. And I think that this subjective dimension of knowledge is inherent in the idea of making a sufficiently coordinated operational contribution. Then finally, a word on the temporal scope of party status. When does it begin and when does it end? The basic rule is simple, I think. As in theory, at least as soon as the requirements that I've outlined are met, a state can be qualified as a party. and once its acts cease to meet the requirements, it also ceases to be a party. In practice, of course, particularly for the end of party status, revolving door situations must be avoided. So it may be helpful in practice to presume that party status persists until that presumption is rebutted by evidence of a qualitatively changed pattern of fact over a prolonged period. This brings me then to the final part of the paper. So let's briefly have a look at what the legal framework that I've just tried to discern would mean for the war in Ukraine. First, supplying weapons, and regardless of what kind, does not have a sufficiently direct operational connection in that sense. And the same is true of training provided to Ukrainian troops. To my mind, it's only the actual use of the weapons or the skills acquired by training that directly cause harm as part of military operations. The matter may be somewhat different regarding intelligence cooperation. It has been reported, for example, that the US has provided real-time intelligence on specific targets to the Ukrainian army. Such localization or verification of targets can be part of the targeting process and thus of a military operation. And it seems that the US may well have been aware of the role of its intelligence in this respect. So here we may get pretty close to party status. It depends, of course, on whether the reported patterns are true and to what extent they are. And here the US, of course, does not confirm its role in specific military operations. What then about cyber support? Well, cyber operations could be integrated into kinetic military operations that cause harm to the adversary, or they could cause harm by themselves. For now, however, we don't know whether this has been the case regarding the cyber support that Ukraine has received, nor do we know anything about the degree of coordination of such cyber support with Ukraine's military operations. Finally, then, we should not forget that the same criteria would apply regarding military support that Russia has received. Most notably, Belarus has reportedly allowed its territory to be used as a direct launchpad for specific military operations earlier this year. Now, I won't go into details on Belarus before Professor Ronen will speak, but I think Belarus may well be, or at least have been, a party, depending, of course, on whether and how Belarus and Russia have coordinated in this respect. To conclude, the war in Ukraine has been described as a war fought with techniques from the past, and it's sometimes even been called the last war of the 20th century. But I think in terms of the crucial role that military cooperation plays in this war, the legal challenges of identifying parties that we're facing in the current conflict will be even more pressing in future conflicts. And this is particularly true of cooperation that is facilitated by military technology in the realms of intelligence and cyber operations. So I hope, therefore, that the framework that I've tried to sketch out in my paper can help us to grapple with these issues of identifying parties in future conflicts. And I also hope that states and international organizations will contribute to specifying that framework by articulating their positions on party status, because quite a bit is at stake. Having the greatest possibility with respect to identifying parties is crucial for the accurate application of international law, and thus ultimately for its effective implementation. Thank you.
You should be reimbursed for 2.5 minutes, so thanks for that. Okay, so our next speaker probably does not have to be introduced in this forum, but I will do it anyway. So Professor Yael Ronen is a faculty member at the Academic Center for Science and Law and a research fellow at the Minerva Center of Human Rights here at Hebrew University. Her scholarship focuses on the intersection between human rights, issues of territorial status, and non-state actors. So she's an ideal person to speak about Belarus and Belarus nationals in the conflict in Ukraine. Yael, the floor is yours.
So thank you, everybody. Thankfully, Alexander has already spoken about what the significance is of whether a state is party to a conflict or not. And everybody says it's of great practical importance. And if I have time, as long as you stay awake, I'm good. But if I have time, I'll say something about the practical significance. Oh yes, I do realize I'm the last person before lunch. Yeah, it's alarming here. Okay, but so what I want to do is kind of following up on what Alexander said, to do a case study of Belarus. And here is the significance, is the applicability of the laws of armed conflict. But I think it is important to mention that although we're talking about the significance is for the laws of armed conflict, the question of whether a state is party to a conflict is very much related to jus ad bellum. We need to have a bellum, we need to have a conflict. And I think this plays to some extent into the question of what the criteria should be. So let me start with the idea that there's at least two views as to what the criteria for co-belligerency or party status is. And before moving to mentioning the one that Alexander spoke of, I want to mention the more conservative view, and that is that what is required of a state in order to be a party to a conflict is conduct that would actually trigger a new conflict. If we're talking about international conflict, it would be conduct that triggers an IAC, basically use of force. The threshold for that is very low, but there still has to be use of force. And just to give you an example of a person who took the position that has happened, what you have here is a translation, which I think is fine, of a letter written by the head of the State Border Guard Service of Ukraine to his counterpart on the Belarus side, and that was written on the 26th of February, 2 days after the war had started. And just to remind you, the Belarus involvement at that stage and today was to allow the Russian forces to launch attacks, both ground forces and aerial attacks and missile attacks from Belarus territory. So what the head of the State Border Guard says is, among many things, the Republic of Belarus, together with the Russian Federation, is waging war against Ukraine. And he ends with the words, "God damn you bastards," disdainfully or scornfully. And I think this is the last entertaining bit I can say about this war. Now, he says that they're waging war, and if they're waging war, presumably there's, even according to a conservative view, we would say that there's an international armed conflict. No doubt Belarus is party to a conflict. But I don't think that this is a very strong legal argument for why Belarus is a party. I don't think that it's that easy to say that Belarus was waging war at that stage. So this would be one view. The other view, which I would call more progressive, is that what is required is relevant acts that have a sufficiently direct connection to harm to the adversary. And here I'm kind of paraphrasing what Alexander said, not without all the criteria in it, but I'm basically referring to that. And I think that this progressive view has the potential of granting increased protection to individuals that are affected by the armed conflict, in which case it's a desirable view. Whether it actually does that is a question. I'll get back to that in a moment. And here, if we accept this, if we accept this definition, then we could have a situation where there's the laws of international armed conflict apply without us having established where exactly was the act that began the armed conflict for Belarus in this case. Now, I'm not saying, I think it's quite clear that Belarus has acted in an aggressive manner in the sense that it has allowed its territory to be used by another state in order to launch an attack against a third state. It allowed the Russians to use Belarus territory to attack Ukraine. So this would be an act of aggression according to the resolution defining aggression. But aggression and armed attack are not the same thing. And I would point out that this view basically makes an analogy for something I wrote here, analogy from NIAC. The idea of directly participating in hostilities is not something that is unique to NIAC. It starts with IAC, but we usually think of it more in terms of a situation where one of the parties is is not a state, and we use it broadly there. So there's these two views, and I'm sympathetic towards the more progressive one. And what I want to do is put it to this test and see, so what does that tell us about Belarus? And again, I'm looking at the fact that Belarus allowed its territory to be used for launching attacks against Ukraine. You have here a map that shows, hopefully, why using Belarus territory was useful for Russia. So does that act pass the test of having it as a sufficiently direct connection to harm to the adversary? And here we have two views. One is, one is, let me say one thing before I move on to that. Apologies. Two reservations about the idea of adapting, of analogizing from DPHing to status, co-belligerent status for states. On the one hand, it might increase protection. On the other hand, we would find ourselves in a situation where we're discussing the laws of armed conflict without first having established how the armed conflict actually began between those two states. Now, that's not impossible, and I think a couple of years ago, we dealt with that in the context of Israel and the Hamas. I think it was probably sometime around the war in Gaza in 2014. It's kind of intractable. It doesn't mean that the laws of armed conflict do not apply just because we couldn't point at the moment where the war began. But I'm not sure that this is a path that I would intentionally choose. A second problem is the idea that we're making an analogy from individually directly participating in hostility to states that participating in hostilities or the equivalent. And it doesn't work in the same way. And Alexander mentioned the issue of the revolving door that we have to deal with when we speak about individuals. And there's a problem that in the afternoon, you're a civilian, and in the evening, you're a civilian directly participating in hostilities, and then the morning after, whatever. Try to do that with states. When you talk about states participating as in a conflict, it has implications for individuals, it has implications for other states. It's not something that we can afford to have changing from day to day. It has to be something a little more stable. And directly participating in hostilities as a source or a basis is not very stable. And the third thing, which I will show in a moment, I think, is this joke that I'll have to do. It never works in large audiences, is when you go, do you know what this is? No, I don't either, but here comes another one. So we're going to see that happening here. I'm not surprised that you don't laugh. It doesn't work with a big audience, but you'll see when we get there. So I always try. I never lose hope. So, okay, let's put the progressive test to the test. So we have the report of the OSCE report, to which Professor Sassoli was party, that was issued under the Moscow mechanism, that was issued in April 2022, that said that basically adopted the same test. So under the progressive view, it said that Belarus was not party to the conflict, meaning allowing the use of Belarus territory is not enough to make Belarus a co-belligerent. On the basis of the same facts, Alexander and other people, to my understanding, and if I'm wrong, then it's other people, not you, have said that yes, this does qualify as providing a direct contribution, direct connection to the harm to the adversary. So we've got this new test, and on the same facts, we already have two different views. Does that tell us does that help us very much? Now it's interesting because I looked at the precedent that you mentioned, that the idea that using another state's territory does make that state a co-belligerent is something that the United States has relied on in 2003 with regard to the war in Iraq. And they did regard states from which they were launching attacks on Iraq to be their co-belligerents. So I went to see, why did they make that point? Well, what was the context in which they did it? And from my understanding, they did it. The point was, where they were getting at, was that nationals of those co-belligerents were not entitled to protected person status, because they were not basically protected persons being nationals of a state who find themselves in the hands of a state to which they're not party in the conflict. But here because they're co-belligerents, then they find themselves in the hands of a state of which they're co-party. or co-nationals or whatever. So basically, the United States was relying on this in order to deny people protected status. If that's how it works, maybe this progressive view is not the most desirable. Now, we have to point out that the United States was talking about the relationship or the protection in the relations between the co-belligerents and not in the relationship between enemy states. And then there's another case, the United States itself relied on its own practice in 1970 in the conflict between Cambodia and Vietnam, where they said, well, let's not launch our attacks from Cambodia onto Vietnam because that would make Cambodia our co-belligerent. What's wrong with making Cambodia our co-belligerent? This bit I don't know. So if somebody can enlighten me on this, this would allow a better understanding. But the question of whether the progressive view is desirable or not, I think is not entirely clear. So I think to some extent what we have here is we remain with the inconclusiveness. If we carry the directly participating hostilities dilemma to a interstate level, we don't remove the dilemma. And anybody who's been dealing with this issue of, here in the region, we've been dealing a lot with is what would constitute directly participating in hostilities. It's not an easy answer. Do we want to broaden its scope? I'm not sure. So I want to look at one other action that the and let me add just one more thing actually about the use of territory. If I want to really nitpick, then I would look at not so much the knowingly but the intentionally being involved. Did Belarus actually provide Russia with assistance by allowing its territory to be used for launching attacks? Now, you know that we all know in January and February there were Russian troops in Belarus and they were participating in military drills. On the 16th of February, the Minister of Foreign Affairs of Belarus claimed that the Russian soldiers would leave Belarus after the training ended. Now, on February 23rd, people didn't believe that on February 24th there would be war. So 2 weeks before that, on the 16th, if the Belarus were saying that the Russians would leave, they may have been genuine about it. They may not have known what was going to happen. And that at some point, the Russians just, I'm providing a narrative here. The Russians have just outstayed their welcome in Belarus. And Belarus is not a strong state compared with Russia. I might come back to that later. But did they intentionally allow their territory to be used in that way? Or did they find themselves being, to a large extent, controlled by Russia? And if you accept the alternative narrative, then not only is Belarus not an aggressor here, but it's actually a victim of aggression, because what they have is foreign forces that refuse to leave their territory. And that is a form of aggression too. Now, I'm moving here to the jus ad bellum issue, and I don't want to. But what I want to say is that applying the test to these facts doesn't give us very clear answers. So here's the other element of Belarus' possible involvement in the war, and that is that they have been amassing troops at the border. Now, the latest item of news that I saw about that was on October 10th, and I don't know what's happened since. Like, the media that I've seen has not reported anything. So all we have is apparently Belarus troops on the border. They've not crossed into Ukraine, although they have threatened to do so. So what we have here is a statement from the Belarus president, who said, tell the president of Ukraine and the other lunatics, if they touch 1 meter of our territory, then the Crimean Bridge will seem to them like a walk in the park. Now, this is arguably a threat of use of force. Again, now this is prohibited use of force. This is more than aggression, but it's still not an armed attack. It still does not in itself create the armed conflict. So we're still with the same question of, is this enough to create a party status? I think as long as the Belarus soldiers or troops remain on Belarus territory, then no, they're not participating in hostilities, or they're not contributing to the armed conflict. Once they cross into Ukraine territory, then it's easy, then it's kind of obvious. And we wouldn't be having this discussion at all. And one final thing on this is the fact that all of this takes place under heavy Russian influence or control. Now, there's a Chatham report from March that shows how the Belarus population is not at all supportive of the state's involvement in the war in any way, directly or indirectly, but What we're looking at is what the government is doing, because it's still the government that is representing Belarus in the international community. That's the voice under for the purposes of international law. But the thing is that the analysis indicates that Russia has enough leverage to pressure Lukashenko individually, specifically, and through him, Belarus, into sending Belarus forces into the battlefield. Belarus and Russia this relationship is to a large extent formalized, but it's all there's a strong political element there. Now, I'm not arguing that Belarus is occupied by Russia, but it is heavily influenced. And I was thinking of one way of looking at it, maybe through the articles on state responsibility, which, the closest is Article 6 about the conduct of organs placed at the disposal of a state by another state. And the article provides the conduct of an organ placed at the disposal of a state by another state shall be considered the act of the former state under international law if the organ is acting in exercise of elements of the governmental authority of the state at whose disposal it is placed. Yeah, good luck reading that. But basically it says that if the Belarus troops are acting under in the exercise of elements of governmental authority of Russia, then basically we should attribute their conduct to Russia. I'm not sure this works very well here. I don't have an alternative. So no. So Belarus is still responsible for its own acts. We can't attribute them to the Russians themselves. And one final thing about, so what are the implications? Now, the obvious implication of whether a state is party to conflict or not, we would say, oh, well, POWs, like, do they have prisoners of war status or not? The thing is, it's not really a practical question. If we had individuals involved, like Belarus nationals in Ukraine or vice versa, yes, they would definitely have POW status, but we would also not have this discussion. It would be clear that Belarus is party to the conflict if its soldiers are fighting in Ukraine. That's simply not happening. But I did look at the issue of protected persons, because there are Belarus nationals in Ukraine and vice versa. Now, let me start with the fact that if Belarus is not a party, basically it's a neutral state, then Belarus nationals in Ukraine are not protected persons, because there are diplomatic relations between Belarus and Ukraine, and it's worth mentioning, there's still diplomatic relations between Belarus and Ukraine. They're not the greatest of friends, but that's not what's required. Now, if Belarus is a party to the conflict, if there's a conflict between Belarus and Ukraine, then Belarus nationals in Ukraine are protected persons because they find themselves in the hands of a party to the conflict of which they're not nationals. And it doesn't matter that they still have diplomatic relations, because Article 4 of the Fourth Geneva Convention does not mention diplomatic relations in this context. So this seems to be pertinent. Are they protected persons or are they not protected persons? I do think, however, that so long as there are diplomatic relations in practice, I'm not sure protected person status is that important. So what are the practical implications? I'm not entirely sure. When you find them, you've got the analysis to apply to them. And that's it. Thank you very much.
Thanks, Yael, for also, sorry for making you trip over my bag there. Okay, so thank you for being very punctual. I'll say a few words about the some general aspects of the presentation, and then we'll open it to questions. So I think, one of the basic problems that makes this debate so sticky and hard to resolve is that we're still, all of us, not entirely sure what IHL does. Is it permissive? Is it prohibitive? Is it something in between, which I like to call facilitative? And I think really at the end of the day, our understanding of the function of IHL should push us towards a higher or lower threshold for party status. And it's not easy at all, because it seems that IHL pulls into opposite directions. Some norms are more permissive, some are prohibitive. And this is something that we still haven't resolved. And I think here lies the core of the legal problem. Moreover, I think we could benefit with more engagement. And Alexander, you in the presentation, you did it a bit more than in the paper, with the political stakes of the legal category of co-belligerency, because I think, really this is a central issue. It seems that regardless what law says, the co-belligerency category, once legally recognized, can contribute to escalation and provide some public legitimacy for targeting and other belligerent measures, even if they're prohibited under jus ad bellum. And I think this also should be more central to the debate. I'm not sure that the public can perceive the nuanced distinction between lawful under in bello and unlawful under ad bellum. And this is something that we have as lawyers, or some of us that are legal realists, have to take into consideration. Now, Alexander, I agree that recognition as party might confer legality under in bello for its attacks, even though they're still prohibited under jus ad bellum. But I would also add, and this was missing from the analysis, and I think can contribute to it, that these attacks can also be unlawful under international human rights law. If we look at General Comment 30 of the Human Rights Committee, and we have a distinguished member, ex-member, 36, sorry, of Human Rights Committee, killings and aggression are ipso facto violations of international human rights law, specifically the right to life. And I think this fills some of the gap and some of the paradoxes that were also mentioned by Noam in the previous panel. Some also kind of scattershot comments. In terms of why co-belligerency matters, I'd also explore the notion of possible shared responsibility. What happens when we have co-belligerency is there are more grounds to claim that there's shared international responsibility for the actions of the belligerents. I know there's a lot of study now and a lot of work being done on shared responsibility, so it's interesting to see if there's any intersections here. Regarding the temporal aspect of party status, I think technology really complicates this assessment. So how do we treat, and you, Alexandra, assess this, you treat this briefly in your paper. How do we treat one-off cases of intelligence provision? So every few weeks, a state provides real-time intelligence information that fulfills otherwise the criteria you suggested. It kind of reminds me of the first shot debate, whether IHL applies from the first shot. Can there be a micro armed conflict? But that's also, I think, pertinent to the debate. Last, I was kind of struck while reading the OSCE report, and also again in this paper, that you can provide access to armed forces from your territory, and it wouldn't be considered being a party to the conflict. I think it at least requires addressing the relations between this and the definition of aggression, which under Resolution 3314 of the General Assembly, allowing other third-party states to use your territory is an act of aggression. So we have a situation in which a state can commit an aggression and not be a party to an IAC. I don't know, but it's, I think, something that we should look into. So having said that, I don't know if we should respond now. I think it's better to give the audience the chance to contribute. So I'll return to my chair position and Miss, yeah, just introduce yourself, and where's the microphone?
Here.
Okay.
Thank you. And I have a question for Yael with the test of the Belarusian soldier, whether they were in Ukraine or not. And so we might not have an official soldiers of Belarus on Ukraine, and I'm going by the media here, there are this debate or talk about the special forces, special private units from Chechnya and Belarus, which may act independently, but at least with the knowledge of these governments or leaders. So how do we treat that within the test that you presented? Thank you.
You said in Belarus, you mean in Ukraine?
They operated in Ukraine, but there are Belarusian private groups, units, that squad, however you want to call it. Thank you.
Alexander, if I understood you correctly, you said that even if, say, the United States was a co-belligerent with Ukraine, if Russia were then to attack the United States, it would be violating jus ad bellum in regards to the United States. Now, I find that very difficult. We've obviously had a violation of jus ad bellum by Russia, and Ukraine therefore has the right to collective or individual self-defense. If the United States comes to the help of Ukraine, it is actually helping Ukraine to exercise its right for collective self-defense. And clearly then, we are now going to apply the rules of jus in bello to the relationship between the parties fighting. And Russia, then what you are saying, that if Russia now wants to attack a legitimate military target of the United States, which is a co-belligerent and is acting in self-defense of Ukraine, it will be violating jus ad bellum towards the United States. Is that your view? And if you could explain that, thank you.
Okay, so maybe we should answer the two questions.
Okay, so apparently this is me. Yeah, okay. I think the answer to your question, Shani, is that if the relationship between those special forces and the government of Belarus is established to the extent that we would say, Article 8 of our CEWA applies, then Belarus is responsible for then their conduct is attributable to, if their conduct is attributable to the Belarus government, presumably under Article 8 of the Articles on State Responsibility, then when they're operating in Ukraine, obviously the Belarus government it's basically the Belarus government operating in the Ukraine. But it would be a question of their relationship between the Belarus rather than what exactly they're doing. Because I mean, fighting is being involved in armed conflict. I don't think anybody would dispute that. The question is just who is fighting.
Yeah, thank you very much, Professor Kretzmer, for the question. And I think the short answer is yes, that is my view. And I think the reason that would be so is because of the structure of the jus ad bellum. To my mind, that the jus ad bellum applies to individual acts of force that must be either considered to be legal or can be qualified as illegal. And therefore, to my mind, although it may sound perhaps overly legalistic, every individual act by Russia in this war against Ukraine, but also against potential future co-belligerents, would be a separate violation of the jus ad bellum. And from that perspective, I think yes. From that perspective, legally speaking, Russia would still be violating international law, even if it were to act in total compliance with IHL against whomever. So for that's. I take the point that, and this is entirely, of course, very difficult to communicate to the public, as we heard this morning. I often have that experience when I talk to people that it's difficult to communicate. It sounds counterintuitive, and it may not necessarily match the Russian logic. And from that perspective, of course, the mere in bello implication is important because it may much better match the sort of the perception of and the logic that the belligerents themselves apply. Because, I mean, in any event, belligerents tend to think that they're right under jus ad bellum. So whether the opponent is a co-belligerent and thus a party makes a difference in sort of realist terms. But from the jus ad bellum perspective, I think the analysis remains that it's illegal.
Okay, so Magda?
Thank you. Alexander, you partly answered my question. I had a question about whether the arms transports on the way to Ukraine may be legally targeted before they cross the Ukrainian border. And this obviously is coming from me as a Polish citizen who until recently worked for the Polish MOD. And earlier you make a distinction about public not, getting the nuances between ad bellum and in bello. It's not only the public. And when you ask the question, can these arms transports and by extension the personnel who's unloading them be legally targeted, it's a difficult message to get across and effectively implement. But it's effectively been answered by Alexander right now. So I think it's still your position, and I'm curious what Yael would say about this.
Thanks to both speakers. I have a question for Yael. I'm after your presentation, after your paper, I'm still struggling about the status of Belarus in terms of jus ad bellum. So it's if we assume that it's not a party to the conflict still, it's what is Belarus? It's accomplice to the act of aggression, or it's committed to an act of aggression, as plain, if we use plain language of the General Assembly resolution. And I think there are certain implications beyond status of soldiers and nationals. So I'm thinking about criminal law. For example, now there is a lot of debates, of course, very, very far from the practical implementation about the crime of aggression. So we have the provisions that allows the charges of the crime of aggression for the persons who are controlling the political and military action of the states. And I also thinking about the complicity in war crimes. So in German debates, for example, which are, I think, very, 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 some extreme participants also developed the line that by supplying weapons to Ukraine, if hypothetically mostly, yes, the Ukrainians commit war crimes, what would be the consequences of Germany? I think in case of Russia, when we have of course we have a large scale violations of international humanitarian law and commission of war crimes, which all reports that we're now discussing witness. So there are much more questions to Belarus and officials of the states. And finally, you mentioned the diplomatic relations, the relevance of diplomatic relations. I would like to ask you, maybe also comment on that we are in an interesting situation when the victim state, you demonstrated as this letter, but it's not official position of Ukraine. The language which is used vis-a-vis Belarus is very different from Russia. It does mention even the direct, as far as I follow the Ukrainian official statements, they don't use the language of the acts of aggression, at least. And the same we can see in the General Assembly resolutions. There are provisions about Belarus, but they don't say, they use some vague language of complicity, but it's not clear what is the legal implication of that and what is the status of Belarus. The same applies to the sanctions introduced against Belarus in comparison with Russia. So I'm still thinking how we can come to this certain legal status of Belarus for all this matter. Thank you.
Okay, so we have. So first of all, if I tend to be conservative, I know. That doesn't mean I necessarily specifically would advocate the conservative view that there's no international armed conflict until there's been an armed attack. For the purposes or there's no co-belligerency until there's been an armed attack. I'm just thinking that the more progressive view is not without its difficulties. That was my argument. The other thing is, and I'm an academic, I did not expect people to leave here. I did not think it was my role to provide a clear answer with which people would leave the room and know what the situation in Belarus is. Like, seriously. Having said that, going back also to what Eliav said about how could there be aggression without being a party to the conflict, and also what you said, Gleb, we have in international law, we have aggression, we have use of force, and we have armed attack. Now, if we've split the hairs earlier, now we have to deal with what we have out of it. And the fact that there would be differences, if an act is one of aggression but not an armed attack, it would have implications. So we would not have necessarily have the same implications as an armed attack would have. So I don't think there's anything impossible about there having been an act of aggression without, as a result, a state being party to the conflict. Now, it may still be responsible for violations of international law. Aggression commission of war crimes. Oh, no, that would be violations of IHL, if we're talking about state responsibility. Individuals could still be responsible under international criminal law for acts of aggression or crimes of aggression and war crimes, without this necessarily being accompanied by the state being party to the conflict. And that just proves the fact that it's not important to characterize Belarus as party to the conflict. We could still apply the rules of state responsibility. We could still apply international criminal law. So the insistence of characterizing it as a party, I'm still not entirely convinced by it. And yes, I think most of the international statements are about Belarus supporting Russia. And the second report of the OSCE, that's the only term I remember that is used there. What is support? I think I wonder whether it's a term Professor Soli might be able to tell us, a term that is used just to say what the facts are without making any legal commitment. But I agree that the treatment of Belarus is different from that of Russia, and I don't think that Ukraine has ever claimed that Belarus was a party to a conflict.
Yeah, if I may just briefly add on the sort of two points. The first one of there possibly being different results if we look at the same thing from the perspective of different legal regimes. So can there be an aggression without party status, for example? I totally agree that from a sort of technically legal perspective, there's no problem necessarily. It feels awkward, and there I'm with Ilya to say it's aggression without it being an IAC, and I think there have been studies in looking at past practice of the Security Council that usually whenever an act has been identified as an act of aggression, that act could also have been qualified as an IAC, reasonably speaking. But there again, what we also see is that the debates that we're having are separate debates, as a matter of fact. So the debates on thresholds in the use ad bellum, to the best of my knowledge, are usually their own debates and led in their own terms, and not in terms of does it meet the criteria for an international armed conflict under Article 2, Common Article 2 of the Geneva Conventions. Same goes for IHL, where we don't tend to look at would it be a use of force? Would it be an armed attack? Would it be an act of aggression? But we try to discern what the resort to armed force between states means in its own terms. So as a matter of fact, although it makes a lot of intuitive sense to look at these issues together, we have separate debates, and I therefore doubt, although it would be possible for the answers to converge, I doubt that they will, in practice, converge. What was the other issue? On the implications, well, I think there may well be more subtle implications of whether Belarus is a party or not. And that would perhaps take too much time to go through all the details. But I think there are differences. There are differences in how IHL applies to third states. And you're right that under Common Article 1, states have certain obligations, yes. But the scope of these obligations is still contested. And if you're a party, then your obligations are just much more firmly established under international law. And these include positive obligations. These include obligations to take precautions, obligations with respect to protected persons. Now, of course, positive obligations vary in scope, depending on certain parameters. But I think the basis from which you argue for a party is just much more firm. And that's just to give one aspect where it might matter.
Okay, so I had. Thank you. This was very interesting. Some of my answers were somewhat covered. I did also have a question relating to the supply of weaponry, and I was hoping perhaps, Alexander, you can specifically address the issue of the MiGs. And the U.S. concerns, there may have been also concerns in Warsaw, but there were also concerns in Washington that that the mechanisms through which aircraft will be flown into Ukraine from airfields in Poland could in itself I'm not sure whether the thinking was that would render Poland as a co-belligerent, or simply render the airfields themselves as a legitimate military target. But I would be interested to hear whether you think there is something distinct about flying a fighter plane from an airbase in an adjacent country with regard to the application of your criteria. And on the cyber front, I mean, one very interesting dimension of the conflict, which we didn't really discuss so far, has been the involvement of private commercial companies in assuming a significant burden, part of the burden of providing cybersecurity to Ukraine. I'm talking specifically about Microsoft, that has been heavily involved in cyber defense and may have been involved also in what sometimes is referred to as active defense, which deals with neutralizing threats. And the question is whether this, how would you factor the ongoing coordinated involvement of a private company in the analysis, both with respect to the company, but also with respect to the country in which the company is located? Is this not the mirror image of allowing your territory to be used for active hostility, albeit in a collective self-defense maybe context?
Hello, Anne Dienert from Hamburg. I also got a question regarding the US intelligence, the live intelligence to Ukraine and its implication for the use ad bellum. So if we say we look into individual acts and each act is a violation of aggression. If Russia attacks the US now, and it's like the first attack against the US based on the intelligence involvement, does Russia have the right to justification there? Could they argue, well, you kind of were complicit with Ukraine here. It's collective self-defense, yes, but we justify our reaction. What is your point on that?
Okay, well, perhaps I'll start there because it's I can be brief. There's no self-defense against self-defense, to my mind. So that should be. I mean, happy to discuss, but I would say no. They have no case there. And then Mr. Shani, the debates about the mix. To my mind, it seemed to be more the distinction that was being made there seemed to be more of an assessment of the potential for political escalation, really, than for there to be, a legal line that could be drawn. Because to my mind, there is no difference based on what kind of weapon is being supplied. Weapon used here, not even in the sense of IHL, but simply, factually speaking. So I don't really see how why it should make a difference from the perspective of party status, what kind of weapon is being supplied, because even flying, to my mind, even flying the airplanes into Belarus, as long as you're not a part of the hostilities, the military operations, I mean Belarus, Ukraine, I meant, even flying them in there wouldn't necessarily matter. Although, of course, from a strategic risk assessment perspective or whatever, it may be catastrophic. I don't see a legal distinction there from the perspective of party status, at least. And on the cyber question, private commercial companies are a tricky case, of course, and one on which I'm not aware that there is much practice. And I would say that, two prongs to which you perhaps both hinted. For one thing, one could try to consider commercial actors in their own right as parties. Now then, of course, not to an international armed conflict, because there we have a sort of a bar, because only states and international organizations perhaps can be parties to IACs and not non-state actors. In an IAC, if they would fulfill the criteria for being an organized armed group, organization and so forth, then a company could also qualify as a party. That may be difficult for Microsoft, right? It might work for a group like Wagner or so, where we could start arguing. For Microsoft, more difficult. And with respect to allowing the territory to be used, well, I would say that territory must, I think there sort of the question of what is Microsoft comes up incidentally again, because the question is allowing territory to be used by whom? And to become a party, you must allow it to be used by a party. And if Microsoft is just a private actor, then I think it's difficult to justify unless we can attribute the acts of Microsoft to the US.
Any more questions? I think we have time for one or two more. Okay, so if that's the case, so thanks, Yael and Alexander, for a wonderful panel, and for our audience for the thoughtful questions. And we will come back at 2. What's the 2 o'clock? Okay.